The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Please be seated. Turn to the third case on this morning's docket. That is case number 103566, State of Kansas v. Ira Wayne Flynn.
May it please the Court, the State of Kansas appears by Caitlin M. Dixon, Deputy County Attorney for Sumner County, Kansas. May I reserve 3 minutes for rebuttal?
3 minutes is granted.
The first issue I would like to address today is whether the defendant's conviction of rape by force or fear be reversed where the State's evidence through the testimony of the victim is that the intercourse was never consensual, that the defendant's testimony is that the intercourse was initiated with consent, which was later withdrawn. The defense counsel knowingly decided not to request a Bunyard instruction, and the trial court did not give such an instruction. In this case, the State's evidence was that the victim was forcibly raped during the entire encounter, that the encounter was never consensual whatsoever. In Bunyard, however, in that case, the facts of that case differ from this one. In Bunyard, there was evidence that was put on a court from both sides that the encounter started out as consensual and then morphed into a non-consensual encounter when the victim withdrew her consent.
How does that difference make a difference? Why is it not a distinction without a difference when the defense has a right to instructions on its theory of defense? I mean, the fact that they both agreed in Bunyard that it began consensual versus it was a contested issue here, still it formed a part of the theory of defense, didn't it?
Well, in this case, I would argue that Bunyard doesn't apply here. That this was a completely non-consensual case, that the facts of this case are not the same as Bunyard is. Actually, I would argue that this case is more like the Robinson case, which started out like this one. There was evidence put on by the State that the entire encounter was non-consensual, and then Robinson, the defendant in that case, said no, it was consensual. I would argue that this case is more like that one, and the Court of Appeals stated that a Bunyard instruction was not necessary in that case because the facts of the case did not support it. Furthermore, in this case, the defense counsel, he waived the instruction. There was brief talk about it from the record of the case, but the jury never asked about a reasonable amount of time to withdraw. It was never an issue in this case. The State's position is that the sexual encounters were non-consensual from the beginning to the end, and that there was never an issue of her initially giving consent and then withdrawing consent. Furthermore, the defendant's testimony changed in this matter. When he was interviewed by police officers, he interviewed that, okay, first the whole encounter was consensual, and then the victim said no, not here, not on the ground, and then he told the detective at that time, well, maybe I continued on for about a minute or two after she said no, but then he testifies, okay, well, maybe it was 30 seconds to a minute to maybe 2 minutes, roughly. If the court had given the Bunyard instruction, you could even argue it may have been better for the prosecution, possibly, because as I sit here watching my time countdown, you could have jurors in deliberations sitting there and counting down 30 seconds, counting down a minute, counting down 2 minutes as to how long a reasonable amount of time to withdraw might have been, and it could have been they could have come back with the exact same verdict that they came back in this case. I would also argue that that there shouldn't be a reasonable amount of time to withdraw. Rape is sexual intercourse where the victim doesn't consent and the victim is overcome by force or fear. Basically, the result of Bunyard could be, okay, well, if there's a reasonable amount of time to withdraw, the disturbing result could be that men are expected to control their sexual urges eventually, although not immediately upon the withdrawal of consent. When a victim withdraws consent, you immediately have rape. You have the sexual intercourse, and you have the non-consent.
It requires more than the withdrawal of consent. You have to have a continuation by force or fear,
correct.
Don't you?
Correct. And a victim could testify to that as well when if there was initial consent and then she withdrew it, and then when she was overcome by force or fear, instead of saying, okay, are we going to have some arbitrary time? Like, is 30 seconds, is a minute, is 5 minutes? In Bunyard, I believe it was about 5 or 10 minutes that the defendant continued, and that was found to be unreasonable. I would argue that the statute itself is enough, that you have sexual intercourse, that you have a lack of consent, and then you have force or fear.
Did we agree that with your second, or your alternative argument, that Bunyard should be overruled?
Mm-hmm.
Where does that leave?
It leaves the statute. It leaves.
Where does that leave this case?
Case, right.
This case, the defendant was found guilty of rape by a jury. He was found guilty of one count. The victim's testimony was that it was never consensual.
There would be no such thing as a Bunyard instruction.
Correct.
So the lack of giving a Bunyard instruction in this case would not be error. Would that be your position?
I'm sorry, could you repeat that?
That if we overrule Bunyard, there would be no such thing as a Bunyard instruction, and so the failure for the trial court not to have given the instruction could not be error.
Correct.
So we would affirm.
And the Court of Appeals we would reverse the Court of
Reverse
Appeals.
the Court of
Right.
Appeals.
And the remaining issues that were raised would be remanded
Correct.
back to them.
If there are no further questions.
I want to clarify. You mentioned that the Bunyard instruction was discussed but rejected. My understanding was it was rejected on present showing, that if the jury asked a question, then the court was prepared to give the Bunyard instruction.
Right.
My problem with that is that you're saying that a timid jury that's disinclined to ask question isn't entitled to know the applicable law. I mean, I don't understand why you would wait till a jury question if this is a correct statement of the law.
Well, as I said, I don't think that the Bunyard instruction would have applied in this case. And even if it had, even if this had been a case where the victim initially gave consent and then withdrew it, what exactly was the judge supposed to say beyond the reasonable, that the jury was supposed to use their own experiences and determine what a reasonable time was, look at the circumstances of the case? There wouldn't have been any factors that the judge could have given. I would just argue that the Bunyard case, that a Bunyard instruction should not have been given in this case.
Help me with the practical consequences of this issue a man and a woman are engaged in consensual intercourse, and at some point after the consent was given and the act began, for whatever reason, the woman says, no, stop. And the man then stops instantly. So it seems that a jury would say, well, then he's complied with withdrawal of consent. There's been no rape. Is that right?
Well, then you wouldn't have the force or fear come into factor.
I'm just asking, are you agreeing with what I've said so far?
Yes.
Okay. And if it's not instantaneous or immediate, then it's a jury question as to whether there was a rape?
Whether force or fear came into play. Whether after she withdrew her consent and then force or fear came into play.
And is that an issue of time?
I don't think it has to be.
But does time play any part in that?
Yes, time would play a part in it.
So why not have a Bunyard instruction if there had been evidence of some amount of time had lapsed, whether anything that was not instantaneous?
Because in this case, the state's evidence was that it was never...
I'm not talking about this case. I'm just talking about a theoretical case. Do we give the jury any direction at all to fit facts like that hypothetical?
I would argue that they could use their own common experience and listen to the witnesses, and decide for themselves when or if force and fear came into play, instead of having a time frame about how long force or fear should have come into play, or when the victim should have felt force or fear. I would just have them listen to what the witness said and use their own common experience in determining that.
So they would be determining what appears to be the plain language of the statute.
Yes.
All right, thank you.
From that plain language of the statute, where do you get that time is a factor?
That's not in the statute. That was from Bunyard. The Bunyard case is the one that decided the reasonable time.
Right, but you're not saying the statute encompasses any temporal element.
Correct.
Any further questions of counsel? Thank you, counsel.
May it please the court, Heather Cessna on behalf of Mr. Flynn. I was going to start off responding to some of the initial statements from defense counsel, the state, and then get into the question of Bunyard. First of all, I wanted to clarify, there's this claim that Mr. Flynn knowingly decided not to request this Bunyard instruction, and I just want to clarify for the court, this is not a question of whether or not he explicitly gave up this as a defense. He clearly indicated that this was a defense per his statements to the police and per his testimony at trial. The hang-up that we get into is that basically the conversation that occurred between the district court and defense counsel was that they had this conversation back in chambers, and then they came back out, and the defense counsel says, okay, are we going to give a Bunyard instruction or not, because they've already had some of this discussion back in chambers, and the district court immediately indicates, I'm not inclined to give that unless the jury asks a question, but you haven't really requested it. And so at that point, this is why we're under a clearly erroneous standard, and that's why the Court of Appeals found that we were under a clearly erroneous standard, and I did not cross-petition on that finding, which I probably should have. So, I think for the purposes of whether or not there was a proper objection, that's distinct from whether or not he intended on affirmatively giving this up, because he indicated he wanted that, and he was basically preemptively told that he wasn't going to get it. So, as far as the standard that we're under, that lack of, or the failure to properly make the objection affects that, but I don't think that the state really can honestly claim that somehow my client didn't knowingly decided against asking for the Bunyard instruction. I think it was clear that they obviously were talking about the need for it, and defense counsel was interested in it. He was just sort of preemptively stopped from going ahead and asking for something that the district court had already told him he wasn't going to get at that stage. So I just wanted to kind of clarify the facts surrounding that. The other distinction that the state made was that in Bunyard there was an agreement on consent between the victim and the defendant. I think, Justice Johnson, your question was right on point, and that is, I think that's a distinction without a difference. I mean, I think the defendant is entitled to his theory of defense, and as long as there was some evidence to support that, even if it's his own testimony, the court's been very clear that that's enough to support the potential of giving an instruction on that basis. I think the difference with the Robinson case was that this court held that it wasn't actually part of his defense, that there wasn't a claim. They asked for the instruction, but it wasn't actually a part of his defense, whereas here I think it clearly is. So I think we can distinguish the Robinson case from this one on that basis. And finally, the lack of a jury question on this. I mean, obviously, if the jury would have asked a question, the district court indicated he was going to give the instruction. So if they had asked a question, we wouldn't be here today. I think the lack of a jury question is not necessarily a deciding factor in this case either, because quite frankly, if they thought they understood it and they didn't, they wouldn't have probably asked the question if they were all under the same misunderstanding that it sort of becomes this instantaneous rape as soon as the consent is withdrawn. So I don't think that that's a determining factor as to whether or not he should get the instruction in this case. Obviously, we would agree with the Court of Appeals and ask this court to uphold the Bunyard decision. This certainly doesn't come up terribly often, as you can tell by the few cases that actually have this particular issue in it. But in the circumstances of this case, I mean, there were three rapes, there were 2 kidnappings, there was an aggravated criminal sodomy. All of that, the victim testified, was not consensual and was by force or fear. All of that was acquitted on, with the exception of this one count where my client said that she initially said, when they were on the ground having sex in front of the car, no, not on the ground, and then he kept going and clarified, and she clarified, no, not really. And his testimony was that it was anywhere, and they were both drinking, that it was anywhere between 30 seconds to 2 minutes, sort of to clarify, okay, is she actually withdrawing consent to, is she withdrawing consent for the sex, or is she just asking to move, or does she really, what's happening here exactly? And I think that's a jury question. I think it has to be. And I think the Court of Appeals have correctly decided this issue.
Do you need to have the Bunyard instruction for the jury to consider those factors?
I think that they do because of this. I think that Bunyard clarified for juries that the possibility of the force or fear element also sort of has to naturally incorporate this timing. Like, does he have time to actually respond to the withdrawal of consent? And is there still a intent to continue on in spite of the force or fear element? Because I think the problem is that there's probably a good possibility of misunderstanding as to what force is necessary, and certainly if you're talking in hypotheticals, if you, for instance, have a sex where the victim is being held down consensually during the sex and then all of a sudden withdraws consent, then you've got all of the elements there. I mean, the force of holding down the actual, sexual intercourse and the withdrawal of consent. I mean, I think it clarifies for the jury that no, whether or not the defendant has actually had time to change it up and form the intent to continue on anyway is a fact question. It doesn't automatically, as a matter of law, become rape at that point. And I think that that's a point that's lost in the statutory language as far as realistically what we're going to call rape in a state. So I think that it is necessary, especially in a situation like this where the timing really was an issue and where there was the withdrawal of consent during sex. So, I mean, obviously in a normal rape case that wouldn't necessarily come into play, but under these circumstances I think it is necessary.
Can the same purpose be accomplished in terms of educating or explaining to the jury without the reasonable time language? And so that there was an instruction that indicated that if there's a withdrawal of consent, there not only needs to be a withdrawal of consent, but a continuation under force and fear.
I would be fine with something like that. I mean, I'm not, I mean, the reasonable time to withdraw language obviously comes from the Bunyard opinion itself. I mean, so that's what I think we were all talking about below. But I think making it clear that that's a factual, that it doesn't automatically become rape immediately when the consent is withdrawn unless there are these, you know, the forming of the intent and the other elements. I mean, I think it could be potentially crafted better, maybe. But I think that there has to be, I think that the plain language of the statute is difficult for a jury under the facts of a case like this to understand that it's not, you know, that they really do still have a factual finding to make here. And that's where the plain language, I think, is not enough, and it doesn't really cover what we're talking about, or it's unclear, essentially.
And is that the essence of why this was clearly erroneous, is that it's so unclear that a jury, we have to question the verdict if a jury didn't have that explanation?
Yes, and I think in this case, I mean, the clearly erroneous standard also comes into play because you're also talking about, obviously, I mean, the state spent a lot of time talking this morning about how the victim's testimony was that this was all not consensual, but clearly, under the facts of this case, the jury had negated much of what she had testified to because all of the other counts were acquitted. And my client actually had indicated that not only was everything else consensual, but that actually one of the other incidents hadn't even happened at all. And he was acquitted of all of those with the exception of this one. So I think the fact that they were really relying on or clearly appear to have been relying primarily on his testimony as opposed to hers plays into that clearly erroneous standard, that the combination of his testimony, the fact that they were obviously negating much of what she was saying, and the fact that this language is so confusing when it comes to this specific kind of fact situation, I think that's you know, that we meet the clearly erroneous standard for that reason.
What's your opinion about what we do if we disapprove the Bunyard reasonable time language?
If you disapprove of the Bunyard reasonable time language, I guess it would depend on how you want to do that, because I think there's still a problem, and I think it can be addressed as Justice Lukert was perhaps suggesting with maybe some other wording besides necessarily the phrase reasonable time.
No, I meant specifically with this case.
Specifically with this case, I mean,
if we disapprove and say it wasn't warranted because we just disapprove of Bunyard, what happens with this case?
Then I think it has to be, I think that if Bunyard is no longer good law, then obviously he didn't get a Bunyard instruction to begin with, which was our claim. So, I mean, at this point, I think the rape would be upheld. It would probably have to be remanded back to the Court of Appeals because there were other issues in the brief that the Court of Appeals found moot because they reversed on this issue.
Why wouldn't we say that the law at the time, the controlling precedent at the time of this trial was Bunyard? So he had a right to a Bunyard instruction under the law that would give us a reversal, but on remand direct that the language, the appropriate language would be instruction without reasonable time.
Well, I would certainly like that response.
Thank her later.
Yeah, thank you very much. I'll think it out. I guess I guess technically speaking, you're correct that if the language was at the time, then it probably still needs to be remanded. And maybe that gives the defense counsel the opportunity to ask for an instruction that maybe doesn't have that reasonable time language, but something else that might approximate getting to that problem still. So, well, I mean,
and the problem is, the bottom line problem is that withdrawal of consent is not enough.
Right.
Under Bunyard or no Bunyard or whatever, the statute requires that the act be accomplished by force or fear.
Right.
And so the jury needs to know that withdrawal of consent is not enough, and I'm not certain the facts of this case would make me confident that this jury understood that, having acquitted of all the other crimes that depended on the victim's statement and convicted of the only one that was really proven by the defendant's statement, I don't know how we can be confident that they understood that withdrawal of consent was not enough.
And I mean, I'm okay with the reasonable time to withdraw language from Bunyard. Obviously, if this court is concerned about that specific timing, like I said, I mean, the defense counsel in this case obviously was basing his request on the Bunyard case, and so that was the discussion that they were having. But certainly, I think something else, some other language that gets to this idea, I think is necessary, because under these situations...
But you would agree that you don't have a reasonable time to rape someone. And if there's force or fear employed after withdrawal of consent, that's not permissible simply as a matter of time, is it?
No, I think the key is you need a reasonable time to react to the withdrawal of the consent. And let me give you a slight hypothetical here to illustrate my point. And that is that you could conceivably have a situation where the victim testifies that she withdrew consent and was immediately afraid, or was afraid even before she withdrew consent because of the withdrawal of consent, of what the defendant was going to do about that withdrawal of consent. And so under that situation, you have the fear element, you have the sexual intercourse, you have the withdrawal of consent, and that would, under those circumstances, seem to make that almost an instantaneous problem. But the defendant still needs time to, especially if it's not an unequivocal no, which in this case I don't think it was an unequivocal no. I think it was a question of, okay, are we actually continuing and just changing positions, or are we actually stopping? That they need both an unequivocal withdrawal of consent and time to react to that. So however we cover that time to react to it, I think the problem is that you can get into those situations without that reasonable time language to react, whether it's reasonable time to withdraw or reasonable time to react to the withdrawal of consent, or however you would like to word it. I think that you've got the possibility that just the withdrawal of consent actually could also satisfy the fear element. If she's afraid of withdrawing the consent and goes ahead and does it anyway, then you sort of have this instantaneous rape problem.
But
and so,
is that really a problem? I mean, the legislature seems to have decided that the burden's on the man to know he has a yes.
That what?
That the burden is on the man to know he has a yes.
Well,
and if there's a no, even if it's equivocal, shouldn't there be a pause, an immediate pause in the action to say, do you mean stop altogether? Do you mean, I know this isn't romantic, but I mean really, the law is written pretty absolutely.
Right. Well, and I don't mean to be indelicate at all, but I think there's a difference between pausing and withdrawal. And I think the problem is that the pausing is still technically penetration. And so I think that's where you really get into problems for the defendant's point of view of, okay, I mean, like, it literally, even under the instantaneous reaction, I mean, there's still a second or a split second that it takes to actually withdraw to stop the sexual intercourse. So I think that's where we start getting into these really difficult questions of fact, and that's why I think Bunyard did a very good job of delicately giving us some guidance for the jury that this is a fact question that they still have to determine based on the specific element or the specifics of each case.
We don't have to take into account mental processing time, just the amount of time it takes to physically disentangle.
I would argue both, but even if you don't take into account the mental processing time, I think you still have a problem of the actual physical part.
A half second?
Even if it's just a half second. Penetration of even the slightest amount is rape. So, I mean, that's where we start getting into these difficult factual questions, which is why I think Bunyard tried to make sure that this was the jury's understanding that this was actually their factual determination.
If consent has been given and then later during intercourse it is withdrawn, and there's a continuation of the act of intercourse, does that automatically qualify as by force or fear, or is there some other label that can be placed on that continuation of the act? I'm struggling to find out what that might be.
I believe the case law in Kansas, and I think even discussed in Bunyard, and the concept of the prosecutorial misconduct issue in Bunyard is that the actual penetration itself isn't necessarily the force necessary, because that's already contemplated as part of the sexual intercourse prong. So I think there has to be some other force. Now, when you get into the question of the fear, then, like I said, I think you've got the potential that a victim could testify that the fear even maybe predated the withdrawal of consent.
But fear isn't enough. We have a causal connection. The force or fear has to be the why the sexual intercourse is occurring without consent. So you have to tie it. Someone can be fearful, like you said, even when they had consent. But so the fear isn't enough. It's the continuation has to be effected through the fear.
Well, and I think that's a jury question ultimately.
Well, but when you talk about the preformed fear, that's just like consent isn't enough by itself. Fear is not enough by itself. They have to all have a causation, a cause and effect.
Right, but I guess when I'm saying that, I think my point is that without that clarification that it's still a factual determination for the jury to make, the jury could think that because those elements are all present, that it's an automatic legal definition of rape without any other factual determination by them, just based on the existence of the fear and the withdrawal of consent. Does that answer your question, or sort of? That was the only issue that we were planning on talking about today, obviously, since we won that issue at the Court of Appeals and the state's petition was taken. There are no further questions.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court. The state's position is that that in this case the sexual intercourse was non-consensual, period. I don't believe there was, and the defendant's theory of the case was that the sexual intercourse was consensual.
And what is the evidence that you think compelled the jury to find non-consensual sex on this particular account?
The victim's testimony at court, that she said no, she tried to run away.
Well, I understand, but that testimony all went to 5 additional counts, all of which were rejected by the jury. And I'm having a little trouble saying that was because there was such compelling evidence from the victim that this was non-consensual, that they would convict of this particular count where the defendant said, yeah, I did it, but I withdrew, or I didn't withdraw fast enough, or I took some time to withdraw. That takes it out of the area of potential jury confusion. I mean, that tells me the jury was struggling with the evidence when they acquit of 5 and convict of 1. The only evidence for which is the only compelling evidence is the defendant's own testimony.
Well, you could also argue that the guilty verdict in this case on that one count just may have been the jury's response to the multiple charges against the defendant arising from essentially one continuous encounter. They could have thought...
This particular rape was the one that involved her saying no, not on the ground, right?
Yes.
And it wasn't the initial.
Correct.
It was in the middle of the alleged acts, as I recall. We started on the hood and we ended in the back seat.
Correct.
And so it seems a little counterintuitive to say that the jury would pick out the middle event and say it's a continuation.
But in this case, you still wouldn't need the Bunyard instruction as the state put on that the whole encounter was non-consensual.
But the defendant, I thought, there was testimony either from what he told the officers or he testified to at trial that there had been consent, and then she appeared according to his words, appeared to withdraw her consent, but he persisted.
Correct.
So my question is, why is that not enough, his own testimony, to get the Bunyard instruction?
In the Robinson case, which I have said is, I believe the facts are more like this one. The female victim testified in that case that all of the sexual intercourse was never consensual, which was her version. And the defendant testified, Robinson in that case, that it was always consensual. And the court said an instruction on the Bunyard defense theory was not warranted based on the facts presented at trial. So in Robinson, you have the defendant saying it was consensual, you have the victim saying no, it wasn't, and then the court saying a Bunyard instruction still was not proper in this case, wasn't proper in this case. And that's what I would submit to the court for this one, is that a Bunyard instruction was not needed.
Could you refresh my recollection on the site to Robinson?
Yes. It's State v. Robinson, 206 P3D 72.
What court is that?
It's an unpublished opinion from the Court of Appeals, 2009.
All right, thank you. Any further questions? Any further presentation?
Isn't the verdict really an indication that the jury believed some part of her story and some part of his, perhaps?
They found him guilty of rape, so I would argue that they believed her.
I mean, they could have followed the instructions and believed the part of his story where he says it was consensual through the first few rapes, for the first three occurrences, but when he threw her onto the ground, that's when it became non-consensual, which he did admit that at some point during that event, she said, no, stop, I don't want to do this on the ground. And what happened afterwards also points or corroborates that fact, that she was raped and that she reported as a rape and that he made the phone calls essentially indicating he believed he'd done something wrong. So, I mean, maybe they believed his story that it was consensual for a while, but when the event happens on the ground, they don't believe him anymore.
The jury could have believed that, but the jury also could have found him guilty on that one count because it was all stemming from one continuing sexual encounter.
Well, that's not how they were instructed. They were instructed as though these were separate events.
I mean, that wasn't your theory, that it was one continuing.
No.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.